Yes, thank you. Excellent, thank you. A very good day, everyone. My name is Sophie Nappert. I am a founder of ArbTech, and we are thrilled to start after the summer break with the first of our webinar series with our friend Federico Ast, the president and founder of the Kleros Cooperative, and Robert Dean, who is also going to present on a project that has recently been developed by Kleros around mediation stroke arbitration, Med-Arb in the jargon. I will introduce our two speakers, and then they will present what the mediation bridge is in the context of Kleros, and then we'll have some time for questions from the audience. Really, Fede and Rob have said they're looking for feedback on this project, which is a very new baby, as I understand it, a few months old. And so please be generous with your comments afterwards, be they in the chat or by email. You have the email of Fede and Rob on the screen if you want to contact them directly or otherwise to speak up. So Federico graduated in economics and philosophy from the University of Buenos Aires, and he holds a PhD in management from IAE Business School. Kleros needs no introduction to our audience. It is a pioneer and a leader in the concept of decentralized justice, and Fede has lectured widely at prestigious academic institutions and amongst lawyers. He's been very patient with our feedback and questions on the topic, but the Kleros construct, I would say, has evolved and developed as a result into something that is really a market leader. I should say also that Fede hosts the first Coursera courses about blockchain and legal tech in Spanish. And I think I'm not wrong, Fede, in saying that your alumni number in the thousands. And so that is something that is a really fantastic demonstration of the power of dissemination. Rob is a chartered quantity surveyor and an RICS registered expert witness. He is very obviously knowledgeable and expert in the construction field, particularly in mixed-use development, healthcare, aviation, oil and gas infrastructure, rail, and tunneling. And this, obviously, Med-Arb is a big phenomenon and very successful one in these industries. And because he is passionate about how technology can help dispute resolution, he and Kleros have developed this project exploring how blockchain technology can be interfaced with infrastructure to create new use cases, opportunities, and efficiencies, I think I would say, Rob, and as well. So thank you very much, both of you, for being with us. I will now leave you the floor, and please let us have your presentation. Thank you.
Thank you very much, Sophie. Thanks for those kind words and the instructions. I will proceed with the presentation. So let's start with discussing what Med-Arb is. So mediation arbitration, it's a hybrid dispute resolution process that combines both elements of mediation and arbitration. At its core, Med-Arb is designed to capitalize on the strengths of both mediation and arbitration. Mediation is a facilitative negotiation process wherein a neutral third party, the mediator, assists the disputing parties in reaching a voluntary settlement. The mediator doesn't have the authority to impose a decision on the parties. Instead, the mediator facilitates discussions, helps clarify issues, and guides parties towards mutual agreement. So the goal of mediation is to help parties find common ground and arrive at a resolution that's acceptable to both. Now, in mediation, obviously, if you have a settlement, job's good, job's done. However, there may be instances where you don't necessarily have settlement reached. It could be on a number of issues. It could be on all of the issues. And Med-Arb is essentially proposing that those remaining issues are sent to arbitration. I won't go into too much detail on the arbitration front, but basically, yes, arbitration is a more formal process. It's where a neutral third party, the arbitrator, hears the arguments and the evidence presented by both sides, and it ultimately makes what is more often than not a binding decision. So unlike mediation, the decision in arbitration... Oh, I think you need to go mute.
Yes, please. Please mute yourself so that Rob can have a clear field. Please, thank you.
Yeah, no worries. Unlike mediation, the decision in arbitration is typically final and enforceable, with an arbitration award, similar to a court judgment. So this brings us to the question as to why Med-Arb. So Med-Arb, being the combination of mediation and arbitration into a single process, offers parties a more streamlined approach to dispute resolution. It provides the parties with flexibility and control of mediation, with the assurance that if they can't reach a mutual agreement, there is a definitive resolution that will be provided through arbitration. Now, this is a hybrid approach whereby it can be especially valuable for parties seeking a timely resolution and where they want to basically avoid the time and costs associated with litigation. Now, on the screen is a visual representation of where Med-Arb sits in the ADR processes. Now, you could include conciliation in there as well, alongside Med-Arb. And yeah, as you go over to the right, you become more they are more formalized. And I guess you could also put in there, they tend to become more expensive as you head further towards the right. So Med-Arb, the advantages of it, we're talking here about cost and time efficiency, consistency in understanding the issues and positions of the parties. It provides parties with another opportunity to resolve the disputes if mediation fails. It allows for a more flexible process as parties can tailor procedures based on their needs. Flexibility is the key, really. Now, there are challenges associated with Med-Arb, and one of which is potential bias and impartiality concerns, which we will discuss later in the presentation. But essentially, another challenge is parties potentially being less open and transparent during the mediation phase. If they know that essentially the same neutral party, the mediator, is acting as the arbitrator should the mediation fail. So this brings us to the question as to how can we have the advantages of Med-Arb processes whilst overcoming its challenges? And this is where the proposal of the Kleros mediation bridge comes into play. Now,
yeah,
Fede have drafted something here. Yeah, so is it? I shall now stop sharing my screen, Fede, and I'll let you take over here, if that's okay.
Can you see the screen now? Yeah.
Yep.
All good? Well, that was a flawless transition. Thank you. Thank you, Rob. Well, as you know, I'm founder at Kleros, and Rob is a very early day community member with us. And at some point a few months ago, he reached to me and he tells me, look, I think we can use Kleros in the context of what I do, which is mediation. in this way, right? So he explains to me a bit his idea of how Kleros could be used in the context of mediation. And well, we brainstorm a bit, and then we come up with an idea that we call Kleros Mediation Bridge. I don't remember the name where it came from, but I mean, we write this article about how you could use Kleros in this context. That is not the context in which we tend to pitch Kleros and to present Kleros, which we tend to present more as like an arbitration tool, even though I know some people in the audience don't agree with the use of the word arbitration for Kleros because of a number of reasons that we have discussed in other sessions, and we will certainly keep discussing in the future. But let's not go into that rabbit hole today. So we brainstormed a bit and developed this article where we explain how this process could work. So just first a bit about Kleros, so everyone is on the same page. So Kleros is a dispute resolution tool that is based on blockchain, and we typically pitch Kleros with this example. You know, we have Alice and Bob. Like Alice is a entrepreneur from, let's say, France, and Bob is a designer of video producer from Guatemala, and she hires him to do like a video for her company, and then there is a dispute on the quality of the product, and then of course Alice is not going to go to arbitration for a $500 contract in Guatemala, and she's not going to go to court in another country. So the truth is that the world economy has lots of these new realities and new conflicts that nobody thought about basically when the framework for arbitration was developed in the 1950s, right? So how Kleros works, so Alice and Bob make their agreement, and now we have cryptocurrencies, and so she can make a payment into an escrow, and then both agree that if there is a dispute, there's going to be Kleros as an arbitrator, and then if everything is okay, so the money is transferred to Bob, she gets her video, he gets his money, all good. If there is a dispute, money stays locked into this escrow smart contract, and Kleros is going to produce a decision. So Kleros is a decentralized organization that's going to pick a number of jurors who are going to, each of them independently analyze the evidence and evaluate the merits of each party, and then they're going to produce a decision. And a very important thing is that Kleros is built on blockchain, so there is traceability of the process, so everyone can be sure that nobody was tampering with the evidence, no one was tampering with the jury selection process, so everything is traceable in the blockchain. And so the jury is going to evaluate the case, and they are going to make a decision, and then let's say they say that Alice is the winner, so she gets the funds back released by the smart contract, and everything is good. So, but for her, not for Bob, but this can solve disputes at a very low cost. One of the main elements of Kleros is that it has a quite interesting or innovative way to select jurors. So anyone can be a juror at Kleros. Let's say this is a video designer from, I don't know, Vietnam, and she wants to make some money by being an arbitrator in Kleros cases. So for this, she needs to get a token that is called Pinakion, based on, I mean, the name that the ancient Athenians used for their ID. They used to pick the jurors in the popular trial. So, and this is like a lottery ticket. It's a cryptocurrency that gives you the right to be drawn as a juror in Kleros cases. So if you want to be a jury, in the jury, you deposit your token into the court where you want to work, and then there's going to be other people that wants to be selected for the jury, and then they also make the deposit of the token, and then Kleros randomly selects a panel of arbitrators for the case. And these are the guys who are going to solve the case. Because of this very innovative mechanism design, one of the main advantages of Kleros is that it is extremely cheap, and it is extremely fast. Kleros can resolve disputes at 1/10 of the cost of alternative dispute resolution methods, online dispute resolution methods. We are now doing some tests of Kleros in context of resolving cases in cryptocurrency exchanges, and it's extremely cost effective, like $50 to solve a dispute. Disputes get solved in like 3 or 4 days. And of course, with the transparency that comes from the use of blockchain and traceability. I'm not going to get into all of the game theory behind this because it's not the topic for today. Just going to say that, as Rob mentioned before, we have the world of dispute resolution has lots of different options, and we have typically in the past pitched Kleros in the context of more to the right side, of arbitration procedure, but through feedback from the community and from the discussion we had with Rob as well. So we have seen that Kleros can also provide a solution more in the context of a mediation process. So let me explain a bit how this Kleros mediation bridge works. It's basically a procedure that is developed on 6 stages. From the beginning, where parties need first to, of course, agree to the use of this tool in order to resolve the dispute that they have. And this could be typically done through a mediation and arbitration clause that would be incorporated in the contract of parties. And then after the process starts, there's going to be a mediator coming into scene, and he's going to work with parties to identify the core issues. So, of course, disputes tend to be complex, and they tend to be composed of different elements. So the first step of the mediation bridge is going to be try to break down this complex dispute into a set of simpler claims over more specific issues. Okay, so we have this complex dispute, and you break this down into, like, let's say 3 issues that are going to be addressed separately. So after the mediator helps parties to this breakdown of the issues, he's going to try to help parties to formulate a demand of what do they want from each of these issues that make the dispute, and he's going to also help to gather and produce all of the relevant documentation and evidence that could be potentially used in resolving a case in arbitration, in case this ends up going to arbitration. So after this work, we can maybe end with Alice with a number of positions for issue 1, 2, and 3, and then we have Bob with his own positions, and then the third step is going to be the fourth step is going to be a negotiation process where parties try to one by one go through this bargaining process between in each of the issues, and then if an agreement is reached, so that's the end of the process for that issue, and then that's a settlement. But if there is not an agreement, so this is going to go to Kleros arbitration. Okay, so let's say you do this for issue 1, 2, and 3, and the cases, so the issues that are resolved through settlement are resolved and out of the table, and then for the issue where no agreement is reached, then you will have a Kleros case set up with the positions that were presented by both parties, and you will have a jury made of Kleros experts to produce a ruling. And finally, after we have gone through all of the issues, then there's going to be a final step where the mediator will assist the parties in creating a master agreement where the settlement is going to be formalized, and this is going to be signed by the parties, and this is where the process ends. So this is a big picture of how we envision this process to work. And so it was not to stay such as a theoretical and abstract matter. So we organized like 2 months ago in the Assas incubator of the Panthéon Assas University in Paris, a workshop with a number of experts in mediation and lawyers and people who are interested in ADR, to try to understand how this method could work in a more realistic setting. So this is the session, and we invented a case which was intended to be like a fun, mediation arbitration exercise about a failed space tour company. There is the dispute was between two companies, one called Space Tourism, that was a French company that was building a rocket ship for selling luxury cruises to space. And then this company had partnered with a pharma company, it was a Swiss multinational, that was sponsoring the project and paying for lots of the expenses, right? And so at some point after starting their agreement, there is a PR incident with a drug sold by Big Pharma, and this affects very negatively the reputation of the company and also of the project that the company is sponsoring. And then a dispute starts where Space Tourism, makes a number of accusations of Big Pharma's damaging reputation of the project because of this scandal, and then other things that I'm not going to go into much detail here because it's a bit long, but non-payment of the sponsorship agreement and a claim to Big Pharma to reimburse the Space Tourism company for a bank loan that they took to build the rocket ship. And Big Pharma, actually, of course, they make the response is that Space Tourism had made unrealistic, promises about the sale of tickets and also demands the return of money that was paid. So this was a big, messy, complex dispute with many different elements inside. And so this is how we implemented this workshop. We had two groups, and one group was the Council of Big Pharma, the other was the Council of Space Tourism, and there was a mediator that was facilitating this process. So we took that complex dispute and broke this down into three simpler issues. That was reimbursement of the passengers, then potentially a rebranding of the project to get out of the PR scandal created by this drug incident, and then a discussion on whether the rocket should be repurposed from a passenger rocket ship to like a space lab for research, right? So this is how we ended up breaking down the issues with the help of the groups that were representing both of the parties. So first issue was, should Big Pharma reimburse passengers? Then issue 2, should the project be rebranded into something different? And the third issue was, should the project continue with the original vision of passenger luxury cruise or be repurposed into a research rocket? It turns out that parties started to negotiate on each of the issues as was intended by the mediation bridge, and they did agree that Big Pharma had to refund passengers, and they also agreed on the issue 2 that Big Pharma would stay involved in the project under a rebranding, but they did not agree on this idea of whether to keep the touristic vision or repurposing the rocket. And this is the situation that was, this was the issue that was actually sent to Kleros. And this is the question that was asked to the Kleros jurors in this case. And they also received a deck with all of the information of what each of the options entailed, and also information on what were the incentives of each of the parties, right? And so the jury took this information, analyzed it, and then basically the question that they had to answer in this case was not it was not a legalistic question. It was a question about what is the solution that all of these things considered, would make more sense from the point of view of a reasonable person. And so the jurors from Kleros, they argued that the project had to be repurposed as into a space lab, as option A was telling them. And finally, we produced, after producing all of these agreements, so we had a settlement on issue 1 and 2, and Kleros' decision on issue 3. This was put into the master agreement. This is a document that we used. It's a fake document, but it was nice to use. It's like a theatrical tool to have parties coming to stage and then sign the document. And this is how we developed. So this is how we thought about the process and how we implemented in this, of course, just a test scenario, but with big satisfaction from parties. And the goal was to try to capture some of their insights on some of their feedback and advice on how this process could be implemented in the future. So I'm going to go to Rob now. So I'm stopping my share screen, and you can share yours, Rob, now.
Okay. Okay, can everybody see my screen now? Yep. Oh, okay, so I'll pick back up there, Fede. Thanks very much. So how can Kleros enhance Med-Arb processes? So as we mentioned earlier, one significant component is the potential reduction of bias. So one of the most frequent voiced concerns of traditional Med-Arb processes when the same neutral individual serves as both mediator and arbitrator is the potential for bias. There's a risk that confidential information shared during a mediation could influence the arbitrator's final decision, even if it is unconsciously doing so. As a result, the parties might be less candid during mediation, fearing that the mediator arbitrator could form opinions that might later affect the outcome of the arbitration. Now, Kleros operates on a principle of randomized jurors, as Fede has just explained, and that essentially means that each arbitration case is assigned to jurors who have no prior knowledge or involvement in the mediation phase of the dispute. Now, this ensures that they come into the arbitration with a fresh perspective. And by introducing the new decentralized jurors for the arbitration phase, Kleros effectively eliminates any preconceived notions or biases that might arise from information shared during the mediation. So the jurors only consider the evidence and arguments presented during the arbitration. Now, knowing that the arbitration phase will be conducted by a fresh set of neutral jurors can enhance the trust in the Med-Arb process, and parties can communicate more openly during mediation, secure in the knowledge that this will not influence the potential arbitration phase. So Kleros's integration into Med-Arb allows parties to embrace the collaborative nature of mediation whilst also being assured of a truly impartial and unbiased arbitration should it be necessary. Now, another interesting point is the simplification element of using Kleros. Now, Kleros necessitates that disputes, no matter how intricate, are distilled into the binary or ranked choice scenarios. And this process in itself compels the parties to simplify their arguments and to clarify their positions, zeroing in on their primary points of contention. And as the parties work to formulate their disputes into more straightforward scenarios, they often find that peripheral issues fall away, revealing the crux of the dispute. So this clarity can be invaluable during mediation. And as discussions become more centered on these core issues, there's an increasing likelihood of finding common ground. So the very act of simplifying disputes for Kleros can, in many cases, bring the parties closer to resolution during the mediation phase itself. Besides the simplification benefit, there are in fact other benefits of using Kleros for Med-Arb. As Fede discussed earlier, the system does in fact deliver very fast results, typically 3 or 4 days. And due to its speed, certainly when compared to formal arbitration, it's significantly more cost effective. Now, as we discussed, Kleros being on-chain, there is the element of transparency and accountability, as all decisions are auditable on the blockchain. And with that, and you obviously have the consideration there that parties might not necessarily want all their dirty laundry per se aired in public. So there is the option to redact anonymize case data as part of the process. So coming on to best practices. Now, we have basically just listed a few. There are many here that we can elaborate on, and perhaps we can discuss further. but initially, we're saying that we need to ensure parties understand the decentralized nature of Kleros, and we need to encourage parties to facilitate themselves with Kleros as a dispute resolution process. And part of that will also include a Med-Arb clause in the contract, adapting this clause to include Kleros as an arbitrator in the process. And with that, that brings us to a conclusion, really. So please do give us all your questions. It would be a good opportunity to discuss amongst peers how this might be developed, how we might procedurally put documentation together to better facilitate a mediation process that allows us to integrate Kleros as part of Med-Arb. So thank you very much.
Thank you very much, Fede and Rob. Please, our audience, if there are questions, they are most welcome. As you can see, this is a very forward-thinking use case of Kleros for very practical applications. I mean, I wanted to ask actually to perhaps Rob, but also Fede, who's your target audience? Because the Med-Arb system, to me, I mean, obviously, in the more traditional world, the reason why you would even have mediation inserted is the opposite of what Fede puts forward as the typical use case of Kleros, a one-shot deal, low value between people who don't know each other. I mean, the mediation surely must imply that you have a relationship that you want to preserve. And so for that reason, you don't want to go, otherwise you would go directly to the Kleros jurors and you'd have your resolution immediately. So I wondered, are you targeting a new audience? And if so, which one is it?
It's a very good question. I think essentially what we're trying to do is to facilitate a new way of using Kleros as a means of resolving a different sphere of disputes. Now, when you think of the complexities that are usually involved with mediations, you tend to have a scenario where there's copious amounts of documentation. It's a lengthy process. It's and in order to distill a resolution, it's not something necessarily that you would be able to use straight off the bat with Kleros. So the logic behind us taking the mediation route is that you essentially have this availability of a mediator that can, as part of his processes, step through with the parties with the intention of helping them resolve these issues, to potentially assist them in creating case data that can be used within Kleros. So it's almost a gateway in using this sort of binary versus rank choice dispute resolution system for matters that could potentially be quite complex in nature. So there isn't a particular audience per se, but I would sort of suggest that it could be a wide spectrum, Sophie. It could well be a more complex dispute that is in fact broken down into numerous matters.
And really what I'm hearing you say, Rob, is that you're marshalling the evidence for the later if necessary, for the later arbitration in a way. So whatever goes on in the mediation, if the parties agree, unlike sometimes you see this is all without prejudice, none of that can go before the arbitrators. This is something different. This is something like almost for those disputes that may be more complex, we are actually trying to streamline certain silos of issues for later decision making if necessary. So all of this is open for the jurors of Kleros to see. Am I right about this, or am I misunderstanding?
No, you're right. The mediator wouldn't necessarily breach his impartiality. He would still essentially be conducting the same exercise, but he would be, when they hit an impasse, they would basically have an alternative option that would enable a fast resolution on a matter.
Yes.
And it's having that sort of in the background that would incentivize stepping through a potentially complex dispute in a much faster way. Even if it meant that the vast majority of cases weren't actually put forward to Kleros, if you integrated this as part of a Med-Arb procedure that was potentially used from the outset of contract formation, it could well act to encourage parties to resolve matters prior to actually needing to go to arbitration.
So really, you are setting up a powerful competitor to the DAB process, the Dispute Adjudication Board, in the construction industry, because that's what they're aiming to do, right? To have this body of decision makers who are there to accompany the parties to keep the contract alive, to smooth out any difficulties. And so with the speed in which Kleros is resolving disputes, then that could be something similar. Are you thinking about that as well?
Yeah, that is a very good comparison. It is indeed. Obviously, like DABs are a lot more integrated into the whole process, aren't they? So they're a lot more informed, and these particular niche scenarios would be, like I would say it would be more after the dispute has occurred, and then you've basically got a scenario where you're trying to whittle down a solution based on a mediation scenario. But yeah, it is a valid comparison. Yeah.
Sort of comparison. Yeah. Excellent. As I said, I'm not going to pick apart the mediation and arbitration clause, but I have a couple of questions. I don't know if either one of you could put on slide 40, which has the wording of your clause on the screen, because I think our audience would be, especially the lawyers, I guess, would be quite interested in just seeing what that entails. I understand from what Rob has said, I mean, to be fair to everyone, that they haven't spent hours thinking of this clause, which I think is actually quite good, I have to say. But my question is, this looks like the Kleros Cooperative is becoming an arbitration and mediation center. They have rules, they're administering the arbitration, they're nominating the decision makers. I mean, is this the direction of travel, or have you just put that there and think about it later on? And I don't know, maybe that's a question for Fede.
I personally would say no. I mean, that initially, I think we're a lot more aligned with the existing bodies and trying to sort of fit in there. It was mainly just a theatrical sort of thing, really.
Yeah, no, that's fair. That's fair. But the reference to rules is interesting. Are you thinking of elaborating rules that might be helpful?
I think that
sorry, Fede, you go for it.
I mean, those rules. So we're not, of course, trying to turn the cooperative into a mediation center. I would like that other mediation centers would like to, use this method to adopt this. I mean, it's not our goal at the cooperative is to further develop the protocol to resolve a number of technical issues that would be required for actually this to work. Like, as you know, Kleros has a number of problems when trying to ensure the privacy of proceedings because of the blockchain nature of it. But these are works that we are doing. So our focus is mostly on how to make the protocol a better fit for this type of use case. Also think that, and from the previous question that you asked, so for example, for the way I see this is the following. I mean, for the low value use cases, the website, $200 website.
Yeah.
I mean, you're not going to mediation for this. It's like you want Kleros to make a decision fast, because the time you would have to spend, in preparing your, evidence and all that, it doesn't make any sense.
Yeah.
So everyone agrees on that. When you present Kleros, yeah, you can use this for the freelancer and stuff like that. People tend to agree less on, well, but do you want Kleros to, take part of the job of an arbitrator? And of course not, because Kleros doesn't comply, as we know, with a number of commonly shared and understood ways in which arbitration needs to be conducted. So we have discussed this at length in ArbTech
Yes.
and other forums.
Yes.
But as you mentioned, Kleros can be used to provide at least a part of an arbitration proceeding, which is the evaluation of more factual elements, as something that construction boards could do. I don't know if Kleros is going to replace construction boards. I can imagine construction boards to actually use Kleros to resolve a number of parts of the process. And the good thing about this is that you can have Kleros involved in solving higher value disputes and more complex disputes without having to go into the discussion on whether this is arbitration or not. We are not claiming that this is arbitration. We are just claiming that this is a tool that you can use to assess some facts that are part of a wider arbitration proceeding.
And it's going to be very interesting, Fede, to hear you later in this autumn talk about Kleros 2.0, which is aiming to be less binary and more complex, and I'm sure which will be very rich for this sort of use case as well. The other thing that I found interesting in the clause, and maybe this is not something that you guys have thought about particularly, but the arbitration process will be carried out by 3 Kleros jurors. That's a very small panel by Kleros standards. But I wondered, are you thinking of being more flexible about your number of jurors, or is that just been put there for as a place holder and then put in the usual? Because Kleros starts, I think, with a panel of 5 or 7, something like that. It's certainly higher than 3.
Actually, Kleros typically starts with 3, but because in general what we are trying to do is to minimize cost as much as possible, so it can accommodate this lower value use cases. But in this case, maybe we can have more, because since this involves a higher value dispute, we could start. I don't know if there is value for both parties to have like 11 if you want, or more. That could be done, because I think the cost would not be prohibitive in this case. I can imagine that the amount of jurors to start with would depend on the preferences of the parties that are involved in the process.
And how does the appeal system of Kleros fit into all this? Does it still feature? Does the Kleros system essentially carries on the way it always has? Are we having a sort of to use a blockchain term, a forked version of Kleros? I wonder, or is this something to be discussed in future?
I mean, the Kleros needs to have the appeals, because it's the way in which the mechanics work. You cannot remove the appeals, because that's a way to prevent attacks and collusion and that. However, what you could have is, like, you say, okay, we're going to, in this particular proceeding, we're going to consider, the ruling reached by Kleros up to the second appeal or the first appeal. So for us, this is going to be the best, the decision. So that can be done, and that parties can agree on what is the way in which they want to handle appeals.
It's a very, it can be a very bespoke process in that sense, I guess. Yes. Excellent. Well, I think that's enough from me. I don't know if anybody else has questions, or maybe Fede and Rob, if there are any specific aspects of your proposition on which you would really value the feedback, so our audience can have time to think about it, decant, and then perhaps send their comments. If there's any specific aspects on which you are particularly keen for comments, please tell us.
For me, the main question I have, and I'm not a Med-Arb expert, so Rob is the expert, but so in which types of disputes something like this would make sense? I mean, it wouldn't make sense, as I said, you know, the low freelancer value claim for
it's something else. Yeah.
It would probably be a bit, I mean, too ambitious to try to use this into like oil and gas, you know, especially in the, you know, the early days. But I mean, what type of disputes that I can imagine be like a middle, I mean, sized disputes, maybe in, I don't know, some smaller kind of IP claims where you have to decide of whether some, you know, I don't know. I have no idea. So that's why I would like to have for me, the main feedback is to see what use cases you imagine would be interesting, and how would you think about improving potentially the way in which we thought about this process. Basically, those are my two questions.
Thank you, Rob. Anything on that? Yeah,
I would second that. I think it would be good to get more information as to the potential cases. Obviously, my day-to-day sort of work and the size of the disputes that I deal with are quite high value. So I'm less aware of the smaller value stuff. But I would guess that family law and like disputes over that sort of thing may be more suited to initially trialing this out and testing the procedural processes. But it would certainly be good to get feedback from the peers with regards to this, and you have to start somewhere.
For sure.
But I do genuinely think it's a good way to bridge real world disputes on chain. So yeah,
I mean, it sounds to me like a commercial relationship that is longer lived than just a one-shot deal, where you need to preserve some sort of relationship. It would be in any field of endeavor, frankly. It could be, I don't know, it could be telecommunication, it could be shareholder disputes, it could be, you know, anything else, but that is factual or technological, but not so much relying on legal principle, because that's not the point. That might be, or the way that you have a contract in practice, how it works between the parties, and to have a set of decisions saying, well, this is what the parties want out of this contract, and then to have Kleros decide that, and so that's clear for the parties going forward. That's what I would say as my immediate off-the-cuff reaction, but I'm sure our audience will be in touch. And I just wanted to say, and Fede, thank you for reminding me, this is being recorded. It's going to be on our website, and I'm going to share it with Fede and Rob to also share on their own platforms and media. And so if that will, you can gather more wider feedback from this. If there's nothing else,
let me just add one thing.
Please.
So we are soon launching a new edition of our Kleros Fellowship program. As you know, this is a program where people can do some research about relevant aspects of Kleros. There are different elements that we want to develop, and that we give funding for people from the community to research. So if you want to research on applications of Kleros into this type of mediation settings, we, in the next batch, we're going to have like a specific track on how to use Kleros for mediation, and Med-Arb, and there's going to be a bit of funding for that. It's not a lot, but you can make, if you want to do some research about this, you can earn $1,000 in PNK tokens for a short paper explaining some element that could improve this mediation bridge application. So if you are into like this type of research, I mean, feel free to apply, and maybe you can help us expand this. This started 4 months ago, and we just presented this. This is basically the second time we present this in public. So I guess there's going to be lots of room for improvement into, I guess, figuring out what are the right use cases and what is the best procedure to conduct this. So feel free to apply to the fellowship if you want to research about this.
And just for our audience, the Fellowship of Kleros has been there from the very beginning of Kleros, hasn't it, Fede? I mean, you are which intake is this? You have had many fellows.
Yeah, we had tons of fellows already. This is going to be the 7th batch, and from we had lots of different research topics, and this also we incentivize different topics depending on the evolution of the market. So people were doing research, for example, in the Kleros in energy dispute. Kleros was also people did in construction. People did some research, for example, the very famous Mexico arbitration case that was done in Guadalajara, where traditional court recognized Kleros ruling under a number of conditions. So we have a recording of that. Was done in the context of the fellowship. So so lots of the new ideas we have for products and new research. So we try to channel that through the fellowship, and we will have in the next one also we have a very interesting track we will have besides mediation bridge is Kleros and AI, because we have a number of interactions between AI systems that can be harmful for parties in the sense that they are biased sometimes and they require human oversight.
Of course.
And that's also one of the use cases. I mean, I don't want to get into all of the tracks now.
It's a huge
if you
topic.
Want to,
it's a huge topic. It's
that's
a huge
for
topic.
A new ArbTech session we can do.
Another ArbTech session, yes. Well, thank you for giving me an opportunity to plug our very new podcast session starting this autumn. We have a guest podcaster called Chris Campbell. He's very well known to the arbitration community because he has a very successful podcast called Tales of the Tribunal, and he very kindly agreed to guest as a podcaster for the people that we and our first episode, we have a date, hopefully end October, early November, will be precisely on generative AI in disputes, and so it's absolutely a topic, as everyone knows, of great interest. If there is nothing else from anyone, I will thank our guests very, very much, Federico Ask and Robert Dean, and thank them as well for pushing the envelope, because heaven knows that's much needed, and it's always a pleasure to explore new avenues and how disputes can be less polarized. The dispute resolution means anyway that we can have at the disposal of users, less polarized between the automated and the very expensive and more nuanced. And so thank you both for sharing your thoughts. And please, the audience will, I'm sure, provide their feedback. Thank you very much on the part of myself and the ArbTech team, Mihaela Apostol, who was hosting us on Zoom today, and Sean McCarthy as well. Sarah Hoshiki is also on the call from our moderating team. A very good rest of your day, everyone. Bye.
Thank you. Bye-bye.